Moving on to our penultimate session of the day, and I would invite Professor Jack Anderson from Melbourne Law School to speak on Sport Resolutions UK, which is an independent, not-for-profit dispute resolution mechanism that's been adopted in the United Kingdom. Professor Anderson is a regular contributor to media in Australia, Ireland, and the United Kingdom. In 2016, he was appointed as an arbitrator at the Court of Arbitration for Sport and has appeared in the list of arbitrators at Euro 2016.
So thanks very much for that. I was also the cast arbitrator, the sole cast arbitrator for the Commonwealth Games on the Gold Coast, so I got to see the large Indian team in action at that. First of all, I couldn't fit into the jersey I was supposed to bring. So my son gave me a backup, which is an Irish jersey. He said, Dad, take care of that just in case. That team is in a big final that's the weekend, so if I drift off here, I'm thinking of that final. Play along with me. So I'm here to talk about Sports Resolutions UK. I'm not here to talk about what exists in India at present, but I'm here to talk about how you may think about following this model of dispute resolution. And I suppose first of all I'd like to thank the organisers of this event. I really enjoyed it so far. And I particularly like the bit about British imperialism, but I'll come back to that in a while. And also about esports and fantasy sports in particular. And I'm delighted to be here in India. And I'm here to talk about dispute resolution. But first of all, I want to just briefly give you an idea of what I think sports law is. And in line with one of our sponsors here, I think, I'll talk about a Premier League game, because I know many of you have Premier League shirts on. Going to a Premier League match now is as much law and action as it is sport and play. When you go to that stadium, there are public order offences all over and surrounding you. That stadium itself is a concrete bowl of intellectual property. It's not named after someone anymore, it's named after a sponsor. And when you go in, look at the sponsorship and merchandising that surrounds you. And most importantly, look at the players. Who employs them? Well, in some cases now, it's a PLC, a public limited company. Think of their contracts, sophisticated contracts, reflecting the abridged nature of their careers. Think about what happens if they get injured and their career is ended prematurely. Think about the contract issues there. Or if they want to move before their contract ends. Think about what happens afterwards when some of them then are taken for a doping test. And we talked earlier about doping, and it's something that I want to focus on, because when it comes to these kind of dispute resolution incidences, this is sports criminal trial, if you like. If I was to go down right now and select someone randomly for a dope test, and I could if you fall asleep, you would have to, I would take a bottle, you would have to lift up your shirt, pull down your pants, I could only male to male, and I would have to watch what would happen. How invasive is that? And what goes into that bottle? Now don't answer. But what goes into that bottle is your personal health data. Who stores it? Where does it go? And if you test positive, you are banned now for a default of up to 4 years. And think of that in any employment situation where up to half of your professional career could be gone because of one test. So they are important points. And if you continue on with the Premier League, then when you go home, because you're a sad sports fan, you either look at it again on TV, and it's TV money which underlines sport or underpins sport, or you play esports. So there is sports law in one, but fundamentally it's about players. And this is an important point, dispute resolution, about players' rights in particular. And we've spoken earlier there about human rights. Well, there's no more fundamental human right than the access to an effective remedy, the access to justice. And when you do get that access, if you do, as you have fundamental rights there, the right to a fair trial, that your trial is not prejudged, and that you have the opportunity to make your case. Fundamental principles of natural justice. And they're the kind of things that I want to talk about today in terms of what we do. And I want to give you a kind of, in the brief time I have, a practical perspective. We've heard a bit of criticism of the Court of Arbitration for Sport, but I'm on the Court of Arbitration for Sport and I speak about it. And I agree with some of the criticisms that are made. And if the CAS Secretary General is watching on Twitter, I apologise. And immediately this is in a personal capacity. But I'm also an arbitrator for the International Athletics Federation and for field hockey as well at international level, and also an international arbitrator for Sports Resolutions UK, which is the model I want to talk about when it comes to this type of issue. And what is this issue? Well, it's alternative dispute resolution in sport. It's basically about keeping sports and why do we want to do that? Well, sports wants to do that for lots of reasons. The courts, with due respect, are slow, costly, expensive, adversarial, public in nature. Not everything that sport and its athletes necessarily want. Moreover, the courts throughout the common law world, from the UK to Australia, have consistently said we do not want to deal with sporting disputes. We would much prefer that they were dealt with in-house. But there is one caveat to that. So long as you embed your internal disciplinary processes with fair procedure, and the outcome is fair to all parties. And they're the kind of issues that I want to talk about. How do we embed fairness, natural justice in sports internal dispute resolution mechanisms? And it's not just arbitration, as we keep hearing about. There is a potential for sport to use mediation, conciliation, other means of resolving disputes. It's not always possible, it's not always right, but there are options there as well. Because remember, in the adversarial system, there's a winner and there's a loser. And in terms of sport, which is a small community and where the players want to play on, that's not always necessarily the apt scenario. And what I say when promoting ADR, arbitration mediation, is not just at this international, supranational level, this Court of Arbitration for Sport, but as you can see, it can go down through the levels, international, national sports tribunal, and even your sports governing body. So those are the kind of issues that I want to talk about. What this ADR thing is, how it works at the various levels, and how we embed fairness in internal dispute resolution in sport. And I want to start at first principles, because a lot of people will go into depth and very detailed CAS cases and all of this kind of stuff. But we need to remember what first principles are. And this is where Sports Resolutions UK and other bodies have come from. And the scenario, even for a local sports federation, would be this. Where a complaint is made, where there is a disciplinary infraction, an investigation takes place by the investigating officer of the sport. That investigating officer investigates and may recommend a sanction. And the player has a choice. Accept the sanction, take it and move on, or ask for a full de novo hearing. If we have a hearing and the player remains unsatisfied or dissatisfied, there is an internal right of appeal on technical, fair procedure grounds only, judicial review. And then finally, for some sports, the better resource sports, there is the arbitration route, and which can end up at the Court of Arbitration for Sport. But do you see those first 3 points? They are the key to almost any disciplinary infraction in sport. The initial investigation, the hearing, and the limited appeal. And within all those steps, there is this idea of fairness. There is this fundamental human right issue of fairness or natural justice. And we will mention a CAS case here, and one of the leading CAS cases on this, which explained it in really simple, straightforward, but effective terms, is this International Sailing Federation case. And I'm not going to go through all the points it makes, but I just want to highlight this. In one slide is what a good sports disciplinary tribunal is all about, what a good sports disciplinary process is all about. Whether you call it a national one or a regional or whatever, these are the types of issues that you come up with. The investigation process is first. The investigation process is a prosecutorial process. A sanction is recommended. The investigator doesn't sit on the appeal. The appeal must be impartial. Should the aggrieved party have the right to representation? Now, personally, and I've done hundreds of disciplinary cases, I prefer when lawyers come in because it gives a kind of a procedural effectiveness to it in terms of directions. Okay, but that isn't always necessarily possible. Due notice to the charges, a lot of sports fall down on this, that the aggrieved party is given last-minute notice of the hearing and doesn't exactly know what they've been charged with. Fundamental breach. They must be given the time to reply and obviously given a time in the hearing to present their evidence. What's the standard of proof that's used in a sports disciplinary tribunal? Usually it's the balance of probability, except when it comes to doping. And that makes a very simple point. The more serious the consequences for the act, the more tightly wrapped the procedural fairness must be. And then we need a timely, written, reasoned decision. We heard this morning about such doping cases taking months, maybe even years. It's not that difficult to present a written reason award in the immediate aftermath of the hearing. And then you have your rights of appeal. And these rights of appeal can either occur in some countries on a national level or all the way up to the Court of Arbitration for Sport. And here are some examples. If a country was thinking about adopting a national sports tribunal, here are some examples. The obvious one I'm going to talk about is Sports Resolutions UK. But there are other examples. I was involved in one in Ireland, which is a very small jurisdiction, 4 to 5 million people. But our idea was that lots of sports governing bodies were wasting a lot of legal costs in court. We created an independent arbitral body for them. And we said, from a government perspective, unless you signed up to this arbitration process, it may affect your funding. And in that process, we explained the benefits of arbitration. We didn't oust or deny you access to the courts. We explained the benefits of arbitration. In New Zealand, again, a small jurisdiction, their sports tribunal is on a statutory basis. That's important because it allows you to compel witnesses. In many sports disputes, inability to compel witnesses is a key downfall. And sports disputes in Canada, then, there's a good blended approach of arbitration and mediation, but I want to focus on Sports Resolutions UK, which is a very good model in of itself. And then at the very top of the tree, the Court of Arbitration for Sport. Whether or not it was certainly a creature of the International Olympic Committee, whether it still is, yeah, we'll leave it for that. And remember, all what I'm saying here is coming from the courts themselves. Right back to this early 1970s English case with Lord Denning. Justice can often be done in them, which is private sporting tribunals, better by a good layperson than a bad lawyer. Sport has the expertise and can bring in the expertise to resolve its own disputes and can do so in a timely, cost-effective manner. Okay? And what the courts in the UK and Australia and elsewhere in the common law world have recognised that, yes, sporting justice can be be a little bit rough and ready. Not maybe as rough as the picture there, which is a gladiator, not maybe as rough as that, but it can be robust. These are not formal legal hearings, but so long as the principles of fairness are embedded, we'll let sport deal. And remember the cost if you don't. The reason that the UK brought in Sports Resolutions UK is because of this case, Diane Waddell, an 800-metre runner from the mid-1990s of international quality in England, tested positive for a doping substance. There was no arbitration means for her to go, so she had to go to court. She was of the view that the initial panel that heard her case in British athletics was biased against her, and also that she had problems with the testing procedures. But she had no choice in appealing the initial decision, which banned her for 9 months, but to go to court. And look at the court where she ended up. The High Court, the Court of Appeal, a brief mention in the UK Supreme Court, remitted back to the High Court, ending up in the Court of Appeal. Both her, personally, and the British Athletics Federation were rendered bankrupt as a result of proceedings because of legal costs. And in that place then, it was decided to bring in a sport-specific arbitral body called Sports Resolutions UK. And it's grown from strength to strength. It works for all of the major sporting bodies in the UK. But I must say, it took a while to convince them. It took a long time to convince them. The major sporting bodies do not want to hand over their disciplinary remit to an outside body. So one of the things Sports Resolutions did was it said that on occasion you will have disputes within your sport. And you will find it difficult to get independent people to sit on that panel. In fact, a lot of people will run away from that because sport is such a small community. Well, we at Sports Resolutions can appoint an ad hoc chair or panel for you of totally independent people who will come in and hear the dispute fairly, independently, and cost effectively, and will do so under your rules, your sporting rules. And through that ad hoc process, they begin to develop credibility, develop authority, and develop the trust of even one of the largest sporting bodies in the world, which is the English Football Association. So there's an important role for it. And it's now even it broadened its role. And look what it does for sport now. It runs the UK's national doping panel. It runs the national safeguarding panel, which is to do with children and child issues in sport. It does so using arbitration and mediation. But also, it kind of fulfills the sports ombudsman role as well for the UK by means of reviews and investigations of sport. And sports like that. Sometimes when you have a problem internally in sport, you're just delighted to hand it over to someone else. And I suppose the question is, who are you handing it over to? Okay? Well, you're handing it over to a list of lawyers of both national and international renown, me accepted, but also what is important, and this is a differentiation to other places, and a differentiation to the Court of Arbitration for Sport. They have doctors, former officials, former athletes, a wide range of people involved in sport. So if you have a doping case, the chair may be legal, but you may have a sports doctor, and you may have an ex-official or an ex-athlete. Does that give a very balanced view? And it's an interesting point. And what's also interesting and different from the Court of Arbitration for Sport is with the Court of Arbitration for Sport, there are 3 people appointed. Basically, each side appoints one in the hope that they may remember who appointed them. And then you have an independent chair appointed by CAS. Sports Resolutions appoints all 3. Is that a better system? Is that something for CAS to consider? Well, maybe down the line. It's a relatively small staff, It's an independent, non-for-profit organisation, and the costs, when you compare it to the potential legal costs, are extremely low. And what we have found is that very eminent members of the judiciary, QCs, are only too willing to serve for sports arbitration. But at the other side, they have developed a pro bono panel of lawyers who will represent athletes, which is a hugely important point for the fairness of the process, and also for the entry of new sports lawyers like we have here today. So that's something to consider as well. And it's broadened its remit. Internationally as well. And in this, I suppose, it prides itself on being independent, timely, cost-effective, and expert-driven. That's the idea of it. But with a light touch. It doesn't force its jurisdiction on anyone. It's up to you to integrate it into your jurisdiction. And then it will provide a service, which may just be the light touch that some jurisdictions need. And in fact, in Australia, they've just undergone a major review of their integrity procedures. They have a problem with cheating in cricket, if you remember it. terrible stuff. But they have a problem, so they did a major review. They have mooted the idea of a national independent sports tribunal at a national level, and it's the Sports Resolutions UK that they're looking at. So this is something for others. But finally, I suppose, just a few points that bring it all together is this is the Court of Arbitration for Sport. I've never got to Lausanne. I've done about 7 or 8 cases, but I've never got to Lausanne. One of the reasons I haven't, and this is totally not in any way commenting on any case that I've ever done, is that I tend to do a lot of the cases on the papers, so that the papers can be submitted online and then I give my judgment by way of that, if both parties agree to that. That is a significant reduction of the costs, and it is something that the Court of Arbitration has done more and more on the papers with the sole arbitrator. There is actually legal aid available, but it's post-result. And there's also problems with the advance of costs that must be met by the parties, which can be significant. So that's an issue for the Court of Arbitration for Sport to look at. Yes, there is an issue with appointments, okay, and the closed list, and whether that will survive these European challenges is going to be interesting. My bigger point would be the diversity of appointees and who they represent. And there's only ever been one public hearing, which involved, unfortunately, an Irish swimmer. And there is an issue about the published awards. Okay? Now, many of the reasons that all awards aren't published is because the parties exert the right under the code that it's not done. Okay? I would tend to be more open and transparent and publish as much as you can. Technically, there is no precedent in CAS, but the more you know about how it operates and how it does in an authoritative way deal with certain sports disputes helps the resolution of sports disputes in the future. And there is the issue, I suppose, of consistency, which you'll always get with large arbitration bodies, and whether or not there should be fewer members is a question, and whether or not they should be divided into specific chambers is another question. But lastly, as CAS found out this year, and as all sports find out in the end, a CAS can be appealed to the Swiss Federal Tribunal. And this is a case of a Peru football who successfully did so. And in that sense, it is open to the ordinary courts, as ultimately all sports should be. You know, sport does not stop at the boundary line, or law does not stop at the boundary line or touch line. Okay? But what law should do is ensure that there is fair play both on and off the field. And by doing so, by embedding fundamental principles of human rights, such as fair play. Thanks very much. Any questions?
on the issue of transparency, you mentioned the last point that there's no precedent in CAS. How does the sports tribunal in UK function?
Yeah, it's a problem with arbitration that technically arbitration is to resolve the dispute that's in front of it. But evidently, and it happens in CAS as well, that there is implied priesthood. So that where you see that there is a trend, particularly with the proportionality of sanctions, for example, it builds in a kind of implied priesthood. And I think that's right. The problem we have, and it's not just with the Court of Arbitration before that, I'm not criticizing, but with all arbitration bodies, is what if there are two disputes of a very similar nature, and this arises in football transfers all the time, where the panels come to different ways of concluding on the compensation. How do we reconcile those, and should there be an internal grand chamber type system to resolve that? At the same time, at some stage we have to come to a finality on the decision, and that's what good arbitration is all about, giving clear finality.
I'm just curious, in the UK, what's the scope of judicial review of the arbitral awards? I say this because in India, the award is really only the first stage. Then there's first appeal, then there's second appeal, then you go up to the Supreme Court. So how is this
exactly
sport resolution?
So there are under UK, England and Wales law, there is the Arbitration Act of 1996, and there are very, very specific provisions within that which limit the review of an arbitral award to very procedural grounds and the classic judicial review grounds. And what we have seen is the way the UK courts have interpreted the Arbitration Acts is they see arbitration as a means of resolving the disputes by way of consensus of the parties. Therefore, they are loath to intervene. Other jurisdictions don't take that, and that becomes a kind of almost like a Russian roulette system where you might as well keep going because eventually you may get the result you want. That's not what we want at all.
I got a question regarding. Is it on? I got a question regarding the substantive law that is used in CAS procedures and also the procedure about the arbitral institution in the UK. So what exactly is the basis on which a CAS arbitrator will decide the dispute?
So it can vary, but for example, some of the organizations like FIFA are very specific that the jurisdiction is limited to FIFA regulations. And in default of FIFA regulations, it's Swiss law. Okay? So the argument then is, many Europeans will say, well, what about EU law principles? And why can't you kind of introduce those ones? It's slightly easier with domestic ones, such as the UK, because you can limit it to English law. And that's not unusual where London is the seat of many arbitrations. There's no problem with that. But yes, that is an issue for CAS to grapple with, the impact that the wider law has beyond just sports law and applied Swiss law. In fact, one of the criticisms of sports law is that it is merely applied Swiss
law. Question, what if the Sport Resolutions UK goes in and works under the laws of finalizing the sport law? What if those don't meet sort of principles of natural justice?
Yeah, so this is an important point with Sports Resolutions UK is its education promise. So one of the things it has done for quite considerable time, in parallel with the substantive law, is to go into sports bodies and educate them on good governance. And what you need is, you want Sports Resolutions to do itself out of the job by getting the rule book properly, by getting the internal mechanisms right. If you do that, you limit the appeals. And we did that particularly with Just Sport Ireland. We put a lot of work into constitution, disciplinary regulations, internal means of appeal, and we kind of did ourselves out of the job in the end, which is good. As the first lawyer ever to say that.
With regards to sport, yes.
Hello. Yeah. With regards to Sports Resolutions UK, so where organizations like the ECB or the FA allow disciplinary proceedings to occur there. So in the arrangement between the federation and the resolution body, does the federation give up all rights, or is there some arrangement as to what would constitute the panel? Or
yeah, so the normal procedure is that the party would have to exhaust all their internal means of appeal within the football association, which includes its own arbitration mechanism, and then at a fail-safe there is a limited avenue towards sports resolutions. If both parties agree, they can bypass the FA and go directly to sport, but that's very rare. But it is a fundamental principle. Exhaust your internal remedies first.
thank you.
So, by way of regulation, some sports encourage an alternate remedy system. Like for instance, FIFA has its national dispute committees, and then the DRC and then the CAS. FIBA has BAT. Now, vis-a-vis this, where do you think Sport Resolution UK stands in the pyramid? Any organization like Sport Resolution stands in the pyramid itself?
Yeah, I mean, what they tend to do is there can be a limited right from a sports resolutions to the Court of Arbitration for Sport. But I think what you have to see with a national body is that the bigger sports can take care of themselves on this. What a good thing for sports resolutions is that many of the smaller bodies simply don't have the resources to deal with these issues. So there's a resource for them. Sports resolutions will come in, help them get their disciplinary procedures right, and then, if possible, help them run those procedures. I think that's a huge thing. What these major international federations do, and they'll mix and match as you go along, is important, but not, I think, as important for what Sports Resolutions UK does for wider UK sport.
Hi, so this is a question. So in India, a major problem we have is doping in sports, and it's a huge challenge. Correct me if I'm wrong, but we rank among the top 5 in the world in the cases relating to doping. But my question is more academic in nature. I'll not get into the details of doping and how many athletes and what percentage of athletes get into doping. But academically, when we focus on athletes' rights, the focus is also on fair play and the fellow athletes' rights. So I want to understand the balancing of the two, because when you're focusing on a particular individual athlete's case, are you also focusing on the fellow athletes' interests? Because the fundamental principle of sports law or sports is fair play. So academically, because in practice in India it's a huge challenge, but academically I want to understand how do you balance the two?
Yeah, I mean, well, first of all, the issue of India and doping. Doping is such a wide definition, and it can go from things that to everything. So, the statistics should be looked at in a greater way. But I take your point. And yeah, of course, you are looking at the good of the sport as a whole in terms of doping, and that is why strict liability was brought in. That is. Now the question is, you should be brave enough and confident enough as a sport in your procedures that where athletes challenge them, you take it on individually. I have absolutely no problem with that, because vindicating the rights of a wronged athlete is a hugely important point in validating the system as a whole. But yes, I know exactly that. And just a broader thing about doping, a lot of people have said we should bring in a bit of controlled doping. Let them take it. My view on that is, as a father of a young daughter who's quite sporty, well, if she wants to go on to have an athletics career, then she would have to take certain. She would almost be coerced into taking a certain amount of doping to remain competitive. And I don't like that in that sense. So there is a lot of balancing points of view on that. But that's where your fair procedures are important, because justice should be blind, and your fair procedures should guide you to the right result. That actually sounded better than I thought it actually.
Thank you, Prof. Anderson. Deepti, if you could have your stage.